CPC, CRPC, Punit Chaturvedi. CPC has 158 sections in 11 parts. It has 51 original orders plus 7 amended orders, total 58 orders. It is passed in 1908 with effect from 1/1/1909. 1 to 8 is preliminary. First to 8 sections are preliminary, out of which section 2 is definitions. And part 1 therefore is section 9 to 35A and orders 1 to 21. So part 1 is suits in general, section 1 to 35A and orders 1 to 20. CPC is a central act. Orders state government can also amend. Maharashtra has added a section 9A which challenges jurisdictional issues. Order 1 is plaintiff, defendant is equal to suit. That is order 1. It is parties to the suit. There can be many plaintiffs or many defendants. Order 2, frame of suit. In order 2, frame of suit, there are 2 sections that are to be read. Section 10, stay of suit, res sub judice. Section 11, res judicata. Res sub judice or stay of suit is no 2 suits with the same matter, same parties, same cause of action, therefore are possible. Therefore there is a declaration that is to be given for every plaint that no such thing as above in every petition, on an affidavit on oath, no other matter sub judice. Then section 11, res judicata, let judicial decisions remain once they are decided. No second suit if already decided. So now the orders in seriatim are: order number 1, parties to suit; order number 2, framing of suit; order number 3, agent or a pleader who can represent you in a court. Then comes order number 6, pleadings in general; order number 7, plaint. That is the journey from order 1 to order 7. Now let us see order 3. It is a pleader. Pleader is a recognized agent for the parties. Order 6, 4 and 5 or later on, they are to be disjoined from here. So order 6, pleadings in general, pleadings generally. There you are, plaint is numbered paras are to be there, that to be clearly written, issues are to be clearly mentioned, relief required is clearly mentioned, grievance is clearly mentioned, against whom grievance is there is name and address and identification to be clearly given, and a categorical description of every item has to be given. Order 7 now is plaint. Now let plaint is equal to a mathematical equation if you want to arrive at 9 to 35A sections, that is part 1, plus order 1, plus order 2, plus order 3, plus order 6 and order 7, total milake plaint. Now we will come to section 26 plus order 4, those are left out now. Section 26 and order 4 will be institution of suit, that is filing a suit in court. It is numbered and classified. It is classified into 2 types of suits. One is the rights suit, that is A series, and money suit, that is B series. Next step is inform the other party. Once the suit is instituted and numbered, it has to be informed to the other party because he has to come and defend himself. That is order 5, summons, issue and service of summons. Is inform the other party. Once the suit is instituted, notify the other party to come and defend it. Order 8, defense or a written statement the other party will submit, along with order 3 through his agent or a pleader, a written statement The defense pleader can submit his written statement as a matter of right within 30 days plus date of receipt of summons, from the date of receipt of summons. And if you need an extension, you have to go to court for permission with the reasons. So you will be given an extension of another 60 days. So in total, 90 days from the date of receipt of summons, you have to submit your written statement. Then Order 9. Order 9 is an appearance and non-appearance and consequences of non-appearance of parties and the remedies of those results. Non-appearance of defendant in ex parte order is passed. Non-appearance of a plaintiff suit is dismissed. In case you have a solid ground for such a non-appearance, then you have to go to the court again and move a set-aside petition. And set-aside petition will set aside the order of dismissal or ex parte, and then suit will come back onto the track. Then Order 9, appear plus ex parte plus dismissal plus set aside. And this is how Order 9 covers issues. Order 9, court examines the claims, gives copy to each other, nothing is hidden. Everything that you submit to the court, a copy has to be given to the other party. Order 11, production and discovery of documents, give copy to each other. Order 11A, it covers digital documents, which is introduced via Commercial Courts Act 2015. Order 12, more claims, counterclaims and pleadings and admission of documents. Order 12 deals with admission of documents. Then Order 13, production, inspection, impounding of documents and return of documents. If wrong stamp duty is paid, it's irregular, not illegal. So you have to pay the shortfall of stamp duty, and then your document becomes regularized and used as evidence. Order 13A, summary judgment. Then 13A is a summary judgment, is newly introduced. And then Order 14, framing of issues by the court. Order 14. Order 15, disposal of suit in the first hearing, that is very rarely done. Order 16, summons to witnesses to prove each other's points. Order 16A, summons to witnesses who are there already in prison, in this case or some other case. Order 17, adjournments. Order 18, hearing. Order 19, affidavits, submission of your new viewpoints or new evidences by way of an affidavit. Order 20, judgment. Order 20A, costs. Costs are imposed on the losing party. If you want to challenge the costs, then you have to submit a surety for the cost and then go for challenging of the cost. So, if you want to see what was there in the CPC section 2, there are 3 items whose definitions are very important. One is 2 clause 2, that is decree, 2 clause 9, that is judgment, 2 clause 14, that is order. So 2 clause 2, decree is a formal expression plus adjudication plus rights of parties as decided by the court. 2 clause 9, that is judgment, contains grounds of decree and the reasoning for a decree that is listed out in the judgment. Then 2 clause 14, order. Order is formal expression of decisions of the court other than a decree. So a judgment will be linked to 2 things. One is a decree, the other is an order. So next is section 35A and order 20A regarding costs, and then part 1 is now complete. So 9 to 35A and then orders 1 to 20A, it covers the journey up to first leg, part 1 and complete. Now sections 36 to 74, part 2 is starting. Execution proceedings. Execution is the longest part. It is put in just one single part. It's almost as good as a second trial. And order 21 has the longest order with 109 rules on execution. It covers things like about execution, immovable property, movable property, money suits, attachment and sale, civil arrest of a judgment debtor, a method to protest. And method to protest rules are given under Rule 100 to 109 of Order 21, execution petition. The decree, no challenge or appeal plus appeal failed, then execution will happen. Then Order 22, death, marriage and insolvency, what is the effect of it? Then Order 23, withdrawal, adjustment of suits. Then Order 24, payment in the court. Order 25, security to costs, where you want to challenge the costs in a higher court. Next comes the Part 3, incidental proceedings, and Part 4, suits in particular. Order 26, in conjunction with incidental proceedings, Part 3, it contains examination being given to advocates and others to examine witnesses for inspection of immovable property. Costs of commission are to be shared by both the parties or by whoever singularly wants a commission to be instituted. Then Part 4, suits in particular, read with Order 27 onwards. Order 27, suits by or against government, read with Part 4. There are three categories of suits: by or against government, section 79 to 82, by or against foreign dignitaries after 82, by or against former rulers of India. They are also linked to Order 28 and 27A, Order 27A also, former rulers. Then Order 28, suits by or against military. Order 29, suits by or against corporations. Order 30, partnerships, by or against. Order 31, suits by or against a trust. Order 32, suits by or against a minor. Order 32A, suits by or against in family matters. Orders 33, suits by or against indigent person or a pauper. They are to be read along with Part 5, special suits and special cases, and Part 6, supplemental proceedings. After supplemental proceedings, you will see Order 34, immovable property, mortgages, foreclosures and redemptions. Order 35, interpleader suit, read with Section 88. It is between defendants or between plaintiffs, sharing between when the other side is willing to do its part. Order 36, a special case, confusion leads to a suit in a court. When a court clears the confusing point, then there will be no suit. Order 37, summary suit, pure money suit, admitted liability, like a DP note, like a check that is bouncing, bill that is not collected, IOU letter where payment is not made, defendant to appear within 10 days from the date of summons, and then plaintiff gives a writ of summons to the other party, then within 10 days the defendant should ask for leave to defend. Defendant will not have, as a matter of right to defend. Then Order 38, attachment and civil arrest. Order 39, injunction, which can be temporary as well as permanent. Order 40, then court receiver takes control of property in question. Then you read this with section Part 7, appeals, section 96 to 112. These are appeals. And orders linked to this particular part are Order 41 to 45. Order 41 deals with first appeal linked to section 96 from judgment or a decree. Order 42, second appeal, read with section 100 from judgment or a decree. Order 43, appeals from orders. Order 44, Pauper Appeal. Order 45, Appeal to Supreme Court. In Order 46, Reference, Review and Revision, read along with sections 113, 114 and 115. 113 is for reference, 114 is for review, 115 is for revision. Order 46, Reference. Here, District Court to High Court to clarify a law point, or the central government to Supreme Court, state government to High Court, a single bench to a larger bench in a High Court. This is how reference matters flow on points of law. Then Order 47 deals with review to the same court, read with section 114. Then Order 48, revision by High Court if there is no appeal available on jurisdictional issues, read with section 115. Review different from res sub judice. Next comes the order, section 144. Order given under section 144 is equivalent to a judgment or a decree. Then section 148A, it deals with caveat. Winner needs a prior notice if loser appeals to High Court. That is caveat. Please listen to me. Caveat is Mera baat suno pehle. Section 151, inherent powers of the court. Where there is no law, the court decides on its own judgment in favor of justice. Okay, then we have orders 48, miscellaneous provisions. Orders 49, chartered high courts. Orders 50, provisional small causes court, provincial small causes courts. Order 51, presidential localities small causes courts. Okay, then under schedules after CPC, there are formats are given, multiple formats numbered A to L. L is added by recent amendment. L is a statement of truth at Commercial Courts Act under 2015. This is CPC complete in short.